Good afternoon and welcome to the Kansas City, Missouri Public Library. This afternoon, we are very pleased to have the League of Women Voters of Greater Kansas City, and they will present information on the November general election ballot measures. And this has been part of a series of presentations that have been held throughout the Kansas City metropolitan area for voters. And we're very happy to have today Mr. Greg Woodhams, who is the Director of Education for the League of Women Voters. We have Mr. Jim Edson, also with the League of Women Voters, Laura Marcus Mountjoy with the League of Women Voters, and Melanie Bussey, also with the League of Women Voters. And each of them will present on a various topics that will be on the November 5th general election ballot. Thank you. And Mr. Woodhams, if you're ready to take it over, we're ready.
Okay, real good. Well, thank you for that introduction, Sharon, and thanks to the Kansas City Public Library for your partnership and for also recording this. Now, I'm going to share my screen here, and um, Sharon, if you could give me a thumbs up if you see use your superpower on your screen. Okay, we are ready to go. Well, good afternoon. It is afternoon, and welcome to Use Your Superpower, which is our Missouri ballot measure information session. I'm Greg Woodhams, the League's voter education chair, and I'm joined here by my teammates Melanie Bussey, Laura Marcus Mountjoy, and Jim Edson. This November, you will have statewide measures on your ballot. Our program today will first inform you of how the ballot measure process works in Missouri. And then after that, our focus will turn to the November ballot measures. We give special attention to the measures dealing with reproductive rights, the minimum wage and paid sick leave, and prohibiting ranked choice voting and requiring citizenship to vote. We will also discuss ballot measures on sports betting and Osage River Casino and fees to support benefits of law enforcement personnel. As the League of Women Voters, we adhere to a standard of non bias and nonpartisanship in our presentation. Our goal is to present you, the voter, with the necessary information to make an informed decision based on an understanding of the views of proponents and opponents. We will not be presenting any position of the League of Women Voters regarding any measure. After our presentation, we will have ample time for questions and answers from the audience. So we're asking that you hold your questions until that time. So thank you for taking the time to attend this presentation, and thank you for taking the time to become an informed voter. Now, Melanie will discuss Missouri ballot initiatives.
Okay. Hello, everyone. In the upcoming general election in November, voters will be selecting their next president, as well as U.S. and Missouri state senators and representatives. In addition, voters will face 6 ballot questions. 5 will amend the Missouri Constitution, and 1 will amend a statute. So, why is this process important to us as voters? We all want a say in our government. Many believe it is our right and our duty to actively participate in our democracy. We want our voices heard. Ballot measures give Missouri voters the opportunity and power to directly decide on matters that affect their daily lives. Because whether ballot measures come from the legislature or through a citizen's initiative, the final decision on the measure is reserved specifically to the voters. Not all citizens can independently change their state constitutions. Missouri is one of only 26 states where citizens can do so. Our current Constitution was written in 1945 and has been amended 119 times.
Mm.
Both citizens and the legislature can propose constitutional amendments. Citizens can attempt to change the Constitution by submitting an initiative petition. The legislature can propose an amendment through a process similar to passing new bills. You will see measures from both on the November ballot. We are going to explain each type of amendment path and tell you about the proposals under each path you will vote on in November. An initiative petition can be started by a citizen or an organization. If a sufficient number of signatures is gathered, the proposed amendment is placed on the statewide ballot for voter approval. Amendment 3, concerning reproductive health care, is an example of a citizens' initiative petition that will be on the November ballot. How can you get a constitutional amendment on the ballot? Has anyone been asked to sign a petition before you go into the grocery store? There are 4 main steps to a citizen initiative getting on the ballot. Step 1, a citizen or an organization starts the process by submitting an initiative petition to the Secretary of State's office. The Secretary of State's office approves the petition form and prepares official ballot summary language. The state auditor prepares a fiscal note summary. Then the Secretary of State certifies the official ballot title, which consists of the ballot and fiscal note summaries. The official ballot title will be on your ballot. The official ballot title must follow the single subject rule and use fair ballot language. What is the single subject rule? The Missouri Constitution restricts ballot measures to one subject and one article of the Constitution. For example, each of the ballot measures before the voters this November deals with only one subject. The sports betting amendment could not have included a proposal on the minimum wage.
Mhm.
Fair ballot language is written by the Missouri Secretary of State and is defined by Missouri law. To be fair, the language has to be a true and impartial statement of the effect of a yes or a no vote, not intentionally argumentative, not likely to bias the voter for or against the proposed measure, and state whether the measure will increase, decrease, or have no impact on taxes. Once the petition has been approved by the Secretary of State, the second step is to gather signatures. Current law requires getting an amount of signatures equal to 8% of legal voters for constitutional amendments and 5% for statute changes in 6 of the 8 Missouri congressional districts.
Mhm.
The third step is to submit the signed petition to the Secretary of State no later than 6 months before the election. In our reproductive rights example, the deadline was May 8th. On May 8th, the sponsors delivered a petition to the Secretary of State with a total of 380,000 signatures versus the approximately 170,000 needed. The fourth step is for the Secretary of State and local election authorities to verify signatures. Local election authorities verify that signatures on petitions match the signatures on voter registrations on file. Around the last Tuesday of July, the Secretary of State announces the findings of the verification effort. The petitioner is notified if the Secretary determines that an insufficient number of signatures has been submitted. Any citizen can appeal that finding, with resolution of that appeal required within 10 days. If the Secretary of State determines that a sufficient number of valid signatures has been submitted, the petition is certified and placed on the ballot. Once on the ballot, a simple majority of votes is needed for passage. It isn't easy getting a citizens' initiative before the voters. Between 2010 and 2020, less than 4% of the ballot measures that were filed by citizens were certified by the Secretary of State's office. However, once certified, the odds of passage improve. In the last 50 years, 66% of the certified ballot initiatives were approved. For example, in 2022, a ranked choice voting initiative petition failed to get the required number of signatures, while the recreational marijuana initiative was certified only on appeal. Now, Greg will discuss attempts to restrict the citizen initiative process.
Thanks, Melanie. In each of the last 3 years, the legislature has proposed measures to restrict the initiative process. In 2024, proposals would have required approval by both a majority of voters and a majority in 5 of 8 congressional districts. These measures did not pass, but will likely reappear in the 2025 legislative session. Of note, the proposed legislation would not have made it more difficult for proposed amendments written by the legislature. It would not have added the requirement of approval in at least 5 of 8 congressional districts. Our state is comprised of 8 congressional districts, each with approximately the same number of people. On the map on the left, notice the difference in geographic size between Urban Districts 5, which is Kansas City, or 1, which is St. Louis. And then look at Rural District 6, which is in northern Missouri, or District 8, which is in southeast Missouri. Those opposed to adding a requirement of a majority of voters in 5 of 8 districts point to how this requirement would dilute the weight of voters in densely populated area. And the map on the right shows the population density in Missouri, and you'll see that the population density is highest in Kansas City over in the west and in St. Louis over in the east. So why do some people want to make the process more difficult? Those in favor of making the process more difficult say that the current threshold is too low, or it is used to advance legislation that the legislature opposes, and interests from outside of Missouri have used the initiative process. What about people who are against making the initiative process more difficult? What is their position? They say the citizen initiative process has served different parties over the years. They also say that increased requirements would make the effort nearly impossible for most groups to achieve, and as a result, the voice and will of the people in a democracy would be silenced. It is easier for the legislature to advance constitutional amendments. Missouri is not alone in seeing attempts to restrict the citizen initiative. 26 states have seen laws advanced to restrict citizen initiatives. Most recently, proposals by the South Dakota and Ohio legislatures to restrict the initiative process were rejected by voters. Now Melanie will provide information on Amendment 3, the Reproductive Healthcare Citizens Initiative.
Thank you. Because of the sensitive nature of this issue, we want to start with a statement made by Justice Harry Blackmun in 1973 as he delivered the 72 majority opinion for the Supreme Court in the Roe v. Wade decision. We forthwith acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes towards life and family and their values, and the moral standards one establishes and seeks to observe are all likely to influence and to color one's thinking and conclusions about abortion. At the time Roe was decided in 1973, nearly all states banned abortion except in certain limited circumstances. Between 1967 and 1973, 4 states repealed their abortion bans entirely, while 13 others enacted reforms that expanded exceptions. For example, to save the patient's life, if the pregnancy was considered dangerous for the physical or mental health of a patient, or if the pregnancy resulted from rape or incest. Roe v. Wade held that under the 14th Amendment and the Due Process Clause, women had a constitutional right to privacy to choose to decide to have an abortion in the first trimester. A state could restrict but not ban abortions in the second trimester. And in the third trimester, when a fetus is viable to survive outside of the womb, a state could ban abortion except when necessary for a woman's health or to save her life. The next major case was Planned Parenthood v. Casey decision in 1992. In this case, the Supreme Court reaffirmed a woman's right to an abortion granted in Roe v. Wade. But Casey also gave states more leeway in passing laws restricting abortion by establishing that restrictions on abortion were unconstitutional if they placed an undue burden on a person seeking abortion before the fetus is viable. Examples of restrictions that were considered not burdensome include requirements on healthcare centers, mandatory waiting periods after initial consultation, requiring that women get ultrasounds or require counseling. That brings us to the Dobbs v. Jackson Women's Health Organization case decided in 2022. The Dobbs case was a legal challenge to Mississippi's 2018 Gestational Age Act, which had banned abortions after 15 weeks, with exceptions only for medical emergencies or fetal abnormalities. In Dobbs, the Supreme Court ruled 6-3 to uphold Mississippi's Gestational Age Act and 5-4 to overrule Roe and Casey. As a result, abortion is no longer protected by any constitutional provision. The current law on abortion in Missouri comes from Missouri Revised Statute 188.017, which was passed in 2019. This so-called trigger law became effective in June of 2022 when the U.S. Supreme Court overruled Roe v. Wade and Casey in the Dobbs decision. The law currently bans abortion except in medical emergencies and states that healthcare providers who violate the law can be guilty of a Class B felony, which can result in 5 to 15 years in prison and have their medical license suspended or revoked. That brings us to Amendment 3, which would establish a right to make decisions about reproductive health care, including abortion and contraceptives, without governmental interference. Here's the fair ballot language. A yes vote establishes a constitutional right to make decisions about reproductive health care, including abortion and contraceptives, with any governmental interference of that right presumed invalid, removes Missouri's ban on abortion, allows regulation of reproductive health care to provide or to improve or maintain the health of the patient, requires the government not to discriminate in government programs, funding, and other activities against persons providing or obtaining reproductive health care, and allows abortion to be restricted or banned after fetal viability, except to protect the life or health of the woman. A no vote will continue the statutory prohibition of abortion in Missouri. If passed, this measure may reduce local taxes, while the impact to state taxes is unknown. And the fiscal note. State government agent entities estimate no cost or savings, but unknown impact. Local governmental entities estimate costs of at least $51,000 annually in reduced tax revenues. Opponents estimate a potentially significant loss to state revenue. The ballot title for Amendment 3 is incorporated in the fair ballot language, which you've already seen. Amendment 3 includes language that would allow abortion to be restricted or banned after fetal viability, except to protect the life or health of the woman. Section 8.1 of the proposed amendment goes on to define fetal viability as a point in pregnancy when, in the good faith judgment of a treating healthcare professional and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus without the application of extraordinary medical measures. To help us understand and navigate the term fetal viability as used in the initiative petition, we are quoting from an article by the American College of Obstetricians and Gynecologists titled, Facts Are Important, Understanding and Navigating Viability. Viability is often used in medical practice in two distinct circumstances. First, viability addresses whether pregnancy is expected to continue developing normally. In early pregnancy, a normally developing pregnancy would be deemed viable. Secondly, whether a fetus might survive outside of the uterus. Later in pregnancy, a clinician may use the term viable to indicate the chance for survival that a fetus has if delivered before it can fully develop in the uterus. Fetal viability depends on many complex factors, of which gestational age is only one. Many other factors also influence viability, such as sex, genetics, weight, circumstances around delivery, and availability of a neonatal intensivist healthcare professional. While it is impossible to definitely declare viability, there are several situations in which a pregnancy will never be viable, regardless of gestational age. Tubal ectopic pregnancies will never be viable, and the treatment for ectopic pregnancy requires ending the non viable pregnancy. Those who support Amendment 3 say passing the amendment will end our state's total abortion ban and make sure Missourians and their families can make the decisions that are right for them. Abortion is an element of women's health care. The decision about whether to have an abortion is a personal choice that should be made by the pregnant woman, their families, and their healthcare providers. Missourians should have the power to make decisions about their own reproductive health care, including abortion, birth control, and miscarriage care, without interference from politicians. Legislative bans on abortion can overlook unique patient needs, medical evidence, individual facts in a given case, and the uncertainty of outcomes in favor of defining viability solely on gestational ages. Those who oppose Amendment 3 say Missouri's current law banning abortion should remain. Human life begins at conception. The pregnant woman's rights should not outweigh the fetus's rights. The time to decide whether or not to have a child is before conception, not after. Gives power to judges and the government to force Missouri taxpayers to fund abortions. Greg will now provide information on Proposition A, minimum wage and earned paid sick time.
Thank you, Melanie. Proposition A is a citizen-initiated ballot question that would change a Missouri statute by raising the minimum wage and mandating earned paid sick leave. In 2018, Missouri voters approved a measure that gradually raised the minimum wage from $7.85 an hour in 2018 to $12 an hour in 2020, where it currently stands. The current minimum wage is not adjusted for inflation. There are currently no Missouri or federal mandates regarding paid sick leave. Under the proposal, all workers will earn 1 hour of paid sick leave for every 30 hours worked. Employers with under 15 employees can limit usage to 40 hours per year per employee, and employers with over 15 can limit usage to 56 hours per year per employee. Sick leave may be taken to care for yourself or family members. Here's the official ballot title. Do you want to amend the Missouri law to increase minimum wage January 1, 2025 to $13.75 per hour, increasing $1.25 per hour each year until 2026, when the minimum wage would be $15 per hour? Adjust the minimum wage based on changes in the Consumer Price Index each January, beginning in 2027, and require all employers to provide 1 hour of paid sick leave for every 30 hours worked. allow the Department of Labor and Industrial Relations to provide oversight and enforcement, and exempt governmental entities, political subdivisions, school districts, and education institutions. Here's the fiscal note. State governmental entities estimate one-time costs ranging from 0 to 53,000 and ongoing costs ranging from 0 to at least 256,000 per year by 2027. State and local government tax revenue could change by an unknown annual amount depending on business decisions. Here's the fair ballot language. A yes vote will amend Missouri statutes to increase the state minimum wage beginning January 1, 2025 to $13.75 per hour and increase the hourly rate $1.25 to $15 per hour beginning January 2026. Annually, the minimum wage will be adjusted based on the Consumer Price Index. The law will require employers with 15 or more employees to provide 1 hour of paid sick leave for every 30 hours worked. The amendment will exempt governmental entities, political subdivisions, school districts, and education institutions from the minimum wage increase. A no vote will not amend Missouri law to make changes to the state minimum wage law. If passed, this measure will have no impact on taxes. Those who support the measure say over 500,000 Missouri families would get a raise through this initiative, pumping hundreds of millions into our state's economy. Over 200,000 Missouri workers lack access to a single minute of paid time off, forcing them to choose between coming to work or sending a child to school while sick or skipping a paycheck. Lack of paid sick leave makes workers more likely to go to work while sick and puts coworkers and communities at risk. Those who oppose the measure say the costs of a higher minimum wage can't always be passed on to customers. Abuse of paid sick leave reduces productivity and increased costs. And workers who misuse sick leave thus force responsible coworkers to cope with a heavier workload. And now here's Jim to talk about Amendment 2 regarding sports betting and Amendment 5 regarding the Osage River Casino, both citizen initiative petitions.
Thank you, Greg. Little background. Currently, Missourians can bet on fantasy sports leagues, but not on live sports events. The Supreme Court legalized sports betting in 2018. Neighboring states have legalized sports betting, but Missouri has not. In the last 3 years, legislation legalizing sports betting was blocked by advocates wanting to legalize both video lottery terminals and sports betting. Amendment 2 seeks to legalize sports betting in Missouri. It legalizes sports wagering on professional or collegiate athletic, sporting, and other competitive events and awards involving human participants, including but not limited to esports or other events as approved by the Commission. The term sports wagering would include bets or wagers made on portions of athletic and sporting events or on the individual statistics of professional or collegiate athletes in a sporting event or compilation of sporting events. Here's the official ballot title. Do you want to amend the Missouri Constitution to allow the Missouri Gaming Commission to regulate licensed sports wagering, including online sports betting, gambling boats, professional sports betting districts, and mobile licenses to sports betting operators? Restrict betting to individuals physically located in the state and over the age of 21. Allow license fees prescribed by the Commission and a 10% wagering tax on revenues received to be appropriated for education after expenses incurred by the Commission and required funding of the Compulsive Gambling Prevention Fund, and allow for the General Assembly to enact laws consistent with this amendment. Here's the fiscal note. State governmental entities estimate one-time costs of $660,000, ongoing annual costs of at least $5.2 million, and initial license fee revenue of $11.75 million. Because the proposal allows for deductions against sports gaming revenues, they estimate unknown tax revenue ranging from $0 to $28.9 million annually. Local governments estimate unknown revenue. A yes vote will amend the Missouri Constitution to permit licensed sports wagering regulated by the Missouri Gaming Commission and restrict sports betting to individuals physically located in the state and over the age of 21. The amendment includes a 10% wagering tax on revenues received to be appropriated for educational institutions in Missouri. A no vote will not amend the Missouri Constitution regarding licensed regulated sports wagering. If passed, this measure will have no impact on taxes. Those who support the amendment say the ballot initiative would allow Missourians to place sports bets in a responsible, regulated manner, funding economic development and classrooms. Missouri loses revenue when residents go out of state to place sports bets. Those who oppose the amendment say compulsive and problem gambling results in social costs. Alternative legislative proposals that would also legalize video lottery terminals would bring in more revenue to the state than sports betting alone. Now let's turn our attention to the Ozark River or Osage River Gambling Citizen Initiative, Amendment number 5. Here's a short history of legal casino boat gambling in Missouri. In 1994, 2 special elections took place to vote on the Missouri Riverboat Gambling Amendment to allow riverboat gambling on the Missouri and Mississippi rivers. The first vote failed by a very slim margin. A later vote on the same amendment passed. In 2008, an initiative sponsored by the casino operators limited the number of casino licenses to 13. This November, Amendment 5, a citizen-initiated constitutional amendment, seeks to allow the Missouri Gaming Commission 1 additional gambling boat license to operate on the portion of the Osage River between the Bagnell Dam and the Missouri River at the Lake of the Ozarks. Here's the official ballot title. Do you want to amend the Missouri Constitution to allow the Missouri Gaming Commission to issue 1 additional gambling boat license to operate on the portion of the Osage River from the Missouri River to the Bagnell Dam? Require that the prescribed location shall include artificial spaces that contain water and are within 500 feet of the 100-year base flood elevation as established by the Federal Emergency Management Agency, and require that all state revenues derived from the issuance of the gambling boat license shall be appropriated to early childhood literacy programs in public institutions of elementary education. Here's the fiscal note. State governmental entities estimate one-time costs of $763,000, ongoing costs of $2.2 million annually, initial fee revenue of $271,000, ongoing admission and other fee revenue of $2.1 million annually, and annual gaming tax revenue of $14.3 million. Local governments estimate unknown revenue. Okay, Here's the ballot language. A yes vote will amend the Missouri Constitution to allow the Missouri Gaming Commission to issue an additional gambling boat license to operate an excursion gambling boat on the Osage River between the Missouri River and the Bagnell Dam. All state revenue derived from the issuance of the gambling boat license shall be appropriated to early childhood literacy programs in public institutions of elementary education. A no vote will not amend the Missouri Constitution regarding gambling boat licensure. If passed, this measure will have no impact on taxes. Proponents say a casino would bring tax revenues and an improved economy to the region. Casinos do not bring crime to a region, as opponents assert. Opponents say casinos bring crime to a region. Residents of the region would see increases in traffic and make the area less family-friendly. Missourians, residents of the region, not Missouri voters as a whole, should decide whether casinos can come. Laura will now turn to amendments that come from the legislature.
Thanks, Jim. The Missouri legislature can put a constitutional amendment on the ballot by passing legislation with a simple majority vote in both the House and the Senate. Unlike a citizens' initiative, signatures are not required. Proposed Amendment 7 regarding prohibiting ranked choice voting and requiring citizenship to vote is an example of a legislatively proposed amendment that will be on the November ballot. A proposed constitutional amendment from the legislature has a much easier path than a citizen initiative petition. This is because it does not require the cost of gathering signatures on the petition. In the case of the recent marijuana initiative, the petition costs exceeded $5 million. A constitutional amendment proposed by the legislature follows a track similar to that of legislation. First, it must be proposed by a legislator and then passed by majority vote in both the House and the Senate. After that, its path is similar to a citizen initiated constitutional amendment. From the past legislation, the Secretary of State crafts and certifies the official ballot title, which consists of the ballot summary language and the fiscal note summary. It is also subject to the single subject rule and fair ballot language requirements. Like a citizen initiative petition, the proposed amendment requires the approval of the voters. Once on the ballot, it also requires a simple majority of votes for passage. Now we'll focus on Amendment 7, an amendment proposed by the legislature to prohibit ranked choice voting and require citizenship to vote. Amendment 7, which would prohibit ranked choice voting and require citizenship to vote, is a constitutional amendment proposed by the legislature and reached the ballot after approval by the majority of the Missouri House and Senate. Here's the ballot title. Shall the Missouri Constitution be amended to make the Constitution consistent with state law by only allowing citizens of the United States to vote, prohibit the ranking of candidates by limiting voters to a single vote per candidate or issue, and require the plurality winner of a political party primary to be the single candidate at a general election. Here's some background. In 2022, a group called the Better Elections Missouri Coalition unsuccessfully proposed a multi-winner system in the primary and ranked choice voting in the general election through the ballot initiative petition process. It proposed replacing the current partisan primaries with open top 4 primaries. In the general elections, ranked choice voting would have been used by ranking the 4 candidates that succeeded from the primaries. A voting method defines how we fill in our ballots. Currently, we have plurality voting, where voters choose one candidate for each office, allowing the candidate with the most number of votes to win. However, this doesn't always result in a majority of votes for that win. These winner take all rules can encourage candidates on the extreme left or the extreme right to cater to base voters in partisan primaries. A number of states have multi winner, nonpartisan primary systems. This results in the top two vote getters, regardless of political party, advancing to the general election. Ranked choice voting is used in many state or local elections. As this map shows, 53 cities across the country use ranked choice voting in their elections. This map shows where ranked choice voting is used in local elections and for military and overseas voting in many southern states. It is also used statewide in Maine and Hawaii, and in presidential, special, and party primary elections in various states. Here's an example of how ranked choice voting might work in a 5-person race. First, the voter ranks all candidates on the ballot in order of preference. Next, the votes are counted and a candidate wins if they have more than 50% of the votes. If no candidate has a majority of the vote, an instant runoff begins. In this example, candidate C received the least votes and is eliminated. Voters that picked candidate C will have their votes allocated to their second choice. A winner is declared if the new count shows a candidate with a majority of votes. If no candidate has a majority, the process is repeated. Our most recent August primary elections resulted in several candidates winning their primary without a majority or 50% of votes. Now remember that Amendment 7 seeks to prohibit ranked choice voting, so those who support the amendment say it protects the one person, one vote standard instead of forcing voters to rank all candidates, prevents efforts of out-of-state funded groups from promoting ranked choice voting as a change to our current election process, and ranked choice voting confuses the voters. Regarding voting systems, those who oppose the amendment, that is, support ranked choice voting, say the proposal denies voters in charter cities and counties from choosing best voting practices for their local elections. Studies of ranked voting methods show increased voter participation, less partisanship, and fewer extremists elected. Multi-winner and ranked voting methods allow voters to vote for candidates they sincerely support without having to be concerned about wasted votes. The ballot question on Amendment 7 also includes language related to citizenship and voting. The Missouri Constitution currently states all citizens of the United States when referring to who can vote. This measure would amend the Missouri Constitution to add language to provide that only citizens of the United States when referring to who can vote. Again, to clarify, the Missouri Constitution already states that United States citizens are the residents who can vote. It's a federal crime that for non-citizens to vote in federal elections. It's also a crime under every state's laws. Those who support the citizenship language in the amendment say, in some parts of the United States, documented non-citizens can vote in school board or other local elections. Missouri proponents would like to prevent the spread of this process. Those who oppose the citizenship language in the amendment say, the citizenship provision will not change who can vote in Missouri and is a distraction from the main issue, which is voting systems. The citizenship issue is regarded as ballot candy, which is including language to sweeten the initiative in the eye of the voter. In addition, the citizenship provision may violate the single subject rule in the Missouri Constitution. Here's the fair ballot language. A yes vote will amend the Missouri Constitution to specify that only United States citizens are entitled to vote. Voters shall have only a single vote for each candidate or issue, restrict any type of ranking of candidates for a particular office, and require the person receiving the greatest number of votes at the primary election as a party candidate for an office shall be the only candidate for that party at the general election, and require the person receiving the greatest number of votes for each office at the general election shall be declared the winner. Wait, there's more. The provision does not apply to any nonpartisan municipal election held in a city that had an ordinance in effect as of November 5th, 2024, that requires a preliminary election at which more than one candidate advances to a subsequent election. A no vote will not amend the Missouri Constitution to make any changes to how voters vote in primary and general elections. Here's the fiscal note. State governmental entities estimate this measure will have no impact on taxes. Now, Greg will talk about Amendment 6, another ballot question from the legislature.
Thank you, Laura. Amendment 6 is a ballot question from the legislature. It would allow levying fees to support salaries and benefits of law enforcement personnel. This measure would include a provision in the Missouri Constitution to include the levying of fees to support salaries and benefits for law enforcement personnel, including sheriffs, former sheriffs, prosecuting attorneys, former prosecuting attorneys, circuit attorneys, and former circuit attorneys. Here's some background information on the amendment. From 1983 to 2021, Missouri imposed a $3 surcharge on every circuit court criminal case in order to finance the Missouri Sheriff's Retirement System. In 2021, the Missouri Supreme Court ruled that collecting fees in court cases to fund the sheriff's retirement is unconstitutional, as those fees were not reasonably related to the expense of the administration of justice. In response to the court ruling, in 2024, the Missouri legislature passed Senate Joint Resolution 71, referring a ballot question to amend the Constitution to the voters, adding language regarding the administration of justice. Here's the official ballot title. Shall the Missouri Constitution be amended to provide that the administration of justice shall include the levying of costs and fees to support salaries and benefits for certain current and former law enforcement personnel? The fair ballot language says a yes vote will amend the Missouri Constitution to levy costs and fees to support salaries and benefits for current and former sheriffs, prosecuting attorneys, and circuit attorneys to ensure all Missourians have access to the courts of justice. A no vote will not amend the Missouri Constitution to levy costs and fees related to current or former sheriffs, prosecuting attorneys, and circuit attorneys. Here's the fiscal note. If passed, this measure will have no impact on taxes. Those who support the amendment say the assessment of fees in courts provides necessary revenue to finance retirement benefits. Supporters also say that without this constitutional fix, the funding for the retirement system will run out within 10 years. Those who oppose the amendment say fees and fines borne by the users of the court system are inefficient generators of revenue. Collection efforts detract from law enforcement efforts, and contributions should be funded from general revenues, which are more stable. They also say that fees and fines are regressive taxes. Today's slide presentation will be available on the voter education page of the League of Women Voters Kansas City website, www.lwvkc.org. You can also get your sample ballot at www.vote411.org. Now, when you go to vote, make sure you're registered to vote. Check your registration. And remember to bring a proper ID to the polls. Proper ID is now a non-expired Missouri driver license, Missouri non-driver license, U.S. passport, or U.S. military ID. And now we'll move to questions and answers. And now, Sharon, we're ready to take any questions from the audience.
I don't see any questions in the chat.
Okay.
You you all the presenters, you thoroughly covered all of the information. In addition, the video from today will be available on the Kansas City's y- Public Library's YouTube page in several days. I want to remind everyone that early no excuse voting begins on Tuesday, October the 22nd. You no longer have to have an excuse to vote early in Missouri. No excuse voting, and there are early voting sites throughout Kansas City. You can check kceb.org for a list. There are 6 sites that are in south of the river, and there are additional sites in Clay, Platte, and Cass counties as well. Just check your local election authority website, and they will tell you where the early voting sites are. And on Saturday, November the 2nd, there will be early voting hours as well. So there's ample time to avoid the rush on November the 5th. I'd like to thank all the presenters today, and we thank you, members of the audience, for attending this live stream of the sample ballot for the November 5th general election. Thank you and have a good day.